Good morning, everyone. Welcome to Bristows. Thank you for joining us this morning on what is undeniably a rather damp, grey morning. So bravo as a first point of call. So this is our first seminar in a series on the digital single market. We have a panel of experts here for you this morning who are going to talk about a range of topics. According to the European Commission, 315 million Europeans use the internet every day, and a digital single market apparently will create up to 415 billion euros in additional growth, hundreds of thousands of new jobs, and a vibrant knowledge-based society. The European Union's plans for a digital single market will affect all aspects of online businesses. They range from issues from e-commerce, data protection, competition, through to copyright. Essentially, the digital single market is built around, or the idea of it is built around three pillars that address how businesses could operate better with a pan-European digital environment. Those three pillars effectively are better access to online goods and services, creating the right conditions for digital networks and services, and maximising the growth potential of the European digital economy. The EU hopes this effectively will level the playing field between the US and Europe and give a greater advantage to European digital businesses, removing fragmentation, opening up markets, and thereby benefiting companies and consumers alike. All this is expected to take place in the next sort of 18 to 24 months, and today we're going to look at the opportunities and the challenges that we think may arise off the back of the introduction of a digital single market. So we've got, just in terms of sort of outline today, we've got two panels for you. We will have some time after each panel to have a Q&A, but actually, because we're going to cover quite a lot of content, I'd actually encourage you to put your hand up if you have a particular question on a topic, and then we can deal with it as we go along. So, first panel this morning, we have Sophie Lawrance, Jeremy Blum, and Theo Savvides, and I'll let each of Sophie, Jeremy, and Theo to just give you a little brief intro to their particular area of expertise, if we may.
So I'm a senior associate in the competition team here at Bristows, so naturally I think that all of this digital single market stuff is all about me.
I'm a partner in the IP litigation department, and it's all about Sophie, so I don't really have much else to say, other than I focused in brands and copyright litigation, and obviously this area is something that's quite exciting and challenging coming up in the next few years.
And I'm Theo Savvides. I head up the copyright and digital disputes part of the practice here at Bristows, so this is really my sweet spot as well.
Thank you. Excellent. So I guess in terms of an overview, could you perhaps give me an idea of what each of you see as priorities arising out of the DSM? I guess you're all going to say your own bit's most important, but Jeremy, let's start with you.
Well, I think from an IP sort of angle, the goal of creating the single market, sort of without frontiers, is going to have massive implications for intellectual property rights. And the two words I think I will be saying over and over again today are probably going to be portability and access or accessibility. And this goes hand in hand with this goal to create a market without any barriers where European consumers or European citizens, I could say, can use the content they've purchased or rented or have got some rights to, or can access platforms or e-commerce sites without any interference. Because at the moment there's various interferences such as geo-blocking or other sort of barriers to access, such as restrictions on shipping or consumer rights issues, and those two, I suppose, access and portability are the key pillars in my mind for what the priorities are in terms of intellectual property.
Yeah, would you agree with that?
Yeah, most definitely. And I think sort of my focus is actually sort of looking at the kind of the reverse of what Jeremy's talking about. So it's a lot of the factors that could potentially undermine the digital single market. So those are things like factors around sort of the lack of harmonisation in the legal landscape, particularly in the copyright landscape. Alongside that, the ongoing problem that there is with piracy and the significant amplification of that problem through the online environment. And then finally, something that I think is perceived at the European Commission level and also I think on the rights holder side of things, which is the unlevel playing field between rights holders and some of those internet platforms who are distributing content around as well from that point of view.
And Sophie, what about you from a
and then,
competition
from
perspective?
a competition perspective, obviously, as our other facetiously said before, a lot of this is about the kind of overall competition landscape in the EU. Essentially, what the aim of this project is, has already been made clear, is to kind of create a single digital market to sort of replicate what the European Commission has already been looking to do in the kind of analogue world for many, many years, reducing barriers to parallel trade and making sure that goods and services are freely available around the whole of the EU. And so as a kind of corollary of that, a big issue is looking at where competition is being hampered and restricted and what can be done about that. And a lot of issues of this kind have been identified through the Commission papers in relation to the DSM. But you've also had, for example, the European Parliament has put out a long paper on competition policy challenges in the digitalized economy, and in that they list a whole raft of other issues like potential issues arising from preemptive mergers. And again, they pick up some of the same issues as the Commission itself has picked up, like customer lock-in and data portability issues. Distortive state aid. I mean, there's an awful lot of different issues going on here, and many of these things have some bearing on competition and how it works. Many of these matters, having said all that, are not exactly issues for competition law as such. So they're more kind of policy issues, consideration of competitive outcomes in future legislation. But some of the areas are more directly relevant to competition law. In particular, geo-blocking is going to have implications for how current competition law is applied and possible future developments in the law. So that's kind of, for me, one of the most key elements of this initiative.
Thank you. And so turning first to e-commerce, what's the focus of the DSM in this particular area? Jeremy?
So it comes back to this borderless economy where people can access any service they want online. And what the Commission's identified at the moment is this barrier for consumers to actually access certain services in the digital world. And the classic example they often cite is the car rental scenario where I don't know if you've ever tried to rent a car in Europe, and I know from first-hand experience, in Germany it's cheaper to rent a car than in Austria. So if you fly into, say, southern Germany, rent your car, and you want to go to Austria, you rent your car in Germany, and then you drive into Austria, and you save a lot of money. And what happens, though, is that the restrictions at present that have been identified are that if say you were an Austrian citizen and you tried to actually access the German rent-a-car website, you might be geo-blocked because they recognise your IP address as that you're domiciled in Austria, and that they have put up this technical barrier to prevent the Austrian person from actually renting the car in Germany. And so there's these technical measures where, in an e-commerce sense, you can justify it on the basis that you're trying to resolve the correct content depending on the residency of the person searching for content, or I should say services. So that's the rationale, and I'm sure everyone's experienced this when they're going on to a European-wide website. And it's not just websites; it can be portals as well. Search on Amazon, and you'll probably be automatically resolved to the Amazon.co.uk site. And so that inability to have complete access to any platform around Europe, and therefore maybe benefit from the let's say cost advantages associated with some portals around Europe, or maybe even different service levels or different say products might be available, and there's a reason you might go to a different website because you want different products in say the Eastern European countries, and that inability to have complete and utter unfettered access has been identified as one of the main issues in terms of the e-commerce side of things.
Thank you. And Sophie, you said that competition law would be most relevant to e-commerce. How exactly does that fit in with what Jeremy's talking about?
So, I mean, we'll come on in a minute to talk about how the law currently applies and how it might apply, but the key thing to be aware of at the moment, as many of you probably already are aware of, is the fact that there is this DG competition specific initiative which sort of supports the overall DSM strategy, which is this sector inquiry in relation to e-commerce. So many of you are probably aware, but the European Commission, and specifically DG Competition, has the power to launch sector inquiries to gather information in relation to particular areas of trade or from particular sorts of companies. So earlier this year it launched a sector inquiry in relation to e-commerce, and since then it's sent out a number of RFIs. Some of you may have had the pleasure of having to respond to some of these in relation to issues such as, in particular, distribution of digital content, and also in relation to platforms. And you know, these RFIs are pretty extensive and powerful tools really for the Commission. The Commissioner, Margrethe Vestager, said that she'd asked her team to make sure that the questionnaires weren't too burdensome for industry, because that was a big criticism of the pharma sector inquiry a few years ago. And so she said, you know, that each inquiry should absolute maximum of 100 pages. And she said, my team came back to me and they'd produced a questionnaire of 99 pages. So, you know, they are very burdensome. They've sought an awful lot of information, lots of supporting documents as well. So, for example, you know, asking if you're providing digital content, you know, you've been asked to supply all of your contracts relating to the procurement of that content. The Commission now will go away and analyse all that. They've been very good at picking up, in my experience, they've been very good at picking up when anyone hasn't provided something. You know, they say, question 53B, you haven't provided the contract that you've referred to in the main answer. So, you know, they've got obviously got a very good system for kind of analysing the information, at least at a superficial level, to check it's all there. And what will they then do with it next? Well, I mean, past experience from the pharma sector inquiry in particular shows that it'll have sort of two purposes, the information they gather. One will be to craft future policy, and in relation to e-commerce in particular, it's likely to be that it will feed into how they review the rules on vertical distribution in the EU, with a particular kind of aim to understand better how digital content is distributed and how digital services are distributed. But the other aspect is always the risk of kind of private actions against particular companies where they've picked up through the sector inquiry that there are potentially restrictive agreements in particular in place. And again, looking back at the pharma sector inquiry, experience shows that that is a very real threat, because there have been, you know, a number of significant investigations following on from the pharma sector inquiry which have led to significant fines. I mean, I think this whole inquiry is perhaps a bit less confrontational than the pharma sector inquiry was, but I think we still can't preclude the fact that they will want to bring some test cases coming out of the investigation.
And what exactly then do companies need to be aware of in that area? How does that fit in?
So, I mean, as I mentioned before, the most significant issue is likely to be geo-blocking, and I think that's the thing that the Commission is kind of trying to work out how to deal with. Its natural inclination is to say there should be no geo-blocking, but we've already seen a bit of a move from talking about companies using geo-blocking to starting to talk about companies using unjustified geo-blocking, because obviously there has to be a recognition that the conditions of competition are very different around the EU, and I think you're going to talk a bit more about that in a bit, Jeremy. In terms of what I think the Commission is mainly looking at, there are two main areas. One is contractual provisions and agreements which may hamper cross-border trade, so kind of reinforcing the existing barriers to trade, if you like. And then the other area is the sort of technical measures that may be put in place by a single company to prevent, for example, customers from accessing content in a different part of the EU. A lot of this isn't really anything new, it's just that it's being applied in a new way because of the new digital landscape. Even that, you know, there have already been cases that relate to very much directly to these issues in the digital context. So, for example, if you look at cases such as the Apple iTunes case a few years ago, the It wasn't the case that ever reached a decision because Apple essentially fell into line with what the Commission asked it to do. But what the Commission pointed out to Apple was that it had, on its iTunes store, it had different prices in the UK, France and Germany. So in particular, the UK was more expensive. And after a short period of investigation, Apple essentially said, fine, we'll just make the price the same in all the countries. So, big win for us as UK consumers because suddenly we're, paying 20 pence less a track for iTunes. And obviously, the thing I didn't say, of course, was that, as a UK consumer, we couldn't purchase from the French iTunes store because Apple had set it up so that you were geo-blocked. And presumably that was at least in part on copyright grounds. So there have been cases of that kind. I mean, I think going forward, the Commission might want to think about those cases in a slightly different way because Apple essentially said, fine, we'll apply the same price everywhere. But I think what a kind of more competitive outcome might be for the Commission to say, well, you don't have to literally apply the same price everywhere. You just have to remove the geo-blocking. And, if you can then still get away with charging a different price, that would be effectively kind of competition almost within the company. What does all this mean in practice? I mean, competition law applies in two main ways. There are the rules relating to agreements, anti-competitive agreements, and there are the rules relating to dominant entities, so prohibiting abuse of a dominant position. The Apple case I've just mentioned was essentially a case about possible abuse of dominance. So, there's already clearly a suggestion that dominant entities operating in the EU may have to be aware about how they apply geo-blocking to different aspects of their services or different national iterations of their services. Equally, as I mentioned just now, the fact that there's already been a bit of a move for the Commission to start talking about unjustified geo-blocking may mean that it's not going to be quite as straightforward for the Commission to actually prove that there's been an abuse of dominance if a company, for example, charges a higher price in markets which can bear it as opposed to other markets where it wouldn't be able to offer the good or service at that price simply because local customers couldn't afford it. And it's clear from the case law that even dominant companies are totally entitled to react to the competitive circumstances in which they find themselves. So I think, if for companies that might be in a dominant position, I think they're going to need to think quite carefully about how they apply geo-blocking type restrictions around the EU and think about the extent to which it can be justified. And if there are circumstances where, the justification is weaker than for other areas, then it would be very prudent to think about other ways to achieve the similar outcome. Having said all that, I think the main issue is going to be in relation to possible anti-competitive agreements. So the main area where issues could arise will be in relation to agreements for distribution of goods or services or content online around the EU, where there might be restrictions imposed on the distributor not to sell in certain countries or to take measures that make purchase across borders more difficult. Again, it's not those sorts of agreements are not always going to be straightforward for the Commission to identify. There's been a bit of a dialing back recently on how easy it is for the European Commission to prove that an agreement is restrictive of competition by object, in particular in the context of two-sided markets, which many digital goods and services operate in that kind of context. Having said that, agreements should, of course, you do need to be careful to make sure that agreements don't reinforce national price differences. There are various options available. Consider whether agency type agreements might work, because with a true agency agreement, it's totally accepted that the principal will impose restrictions on the agent. And some sorts of agreements in the online space have been crafted using agency agreements. So, for example, some of the e-books arrangements that the European Commission looked at were on an agency model. And although those agreements were challenged, what was really being challenged was the fact that there was a horizontal agreement between a number of competing companies and not their actual agency agreements with their distributors. So I think there's still an open question as to whether agency may be a useful way for companies to have a bit more control over how their goods and services are distributed around the EU without there being a kind of constant race to the bottom in terms of price.
And what about enforcement? Are there issues around that? How does that fit in?
Well, I mean, the interesting thing that's arisen over the last few years, and I think part of the motivation for the sector inquiry, is the differences in enforcement between different member states of the EU. So in the EU we have a decentralised regime. We have the European Commission, which enforces issues that kind of affect 3 or more member states, but you also have a national competition authority in every member state. And in this area there's been some significant disparities in the way different competition authorities have enforced the rules, which is obviously pretty problematic when essentially they're really all meant to be interpreting Article 101 and Article 102 of the treaty. And the outlier in particular is Germany. It's taken a much stricter approach to restrictions on internet selling. So for example, it's held that any restriction on a distributor from selling, for example, using an auction platform or a price comparison site, that's regarded as a restriction of competition by object, whereas that approach hasn't been taken in other member states. Similarly, they have taken a much stricter view to agreements between platforms and clients of the platforms, which include kind of price parity or most favoured nation clauses. In Germany, those have all been held to be anti-competitive by object and therefore prohibited, whereas in other countries they've identified a narrower infringement and it's been a kind of effects-based infringement, which has been able to be resolved by commitments. And I think those disparities are one of the key reasons why the Commission was keen to launch the sector inquiry, so that it can kind of get a bit more of a handle on policy across the whole of the EU, and potentially in this context of kind of a review of the rules applying to vertical agreements, which is coming up in the next few years, it can try to put in place something that's a bit of a clearer methodology for all member states, and to reduce those disparities. I think that's probably enough for now, but apart from perhaps just to sum up and say, sorry, you won't hear so much from me after this, but sum up and say that after that, if you're a company that's distributing goods and services across the EU, your easiest position is if you're non-dominant and vertically integrated, because then that enables you essentially to avoid all of the 2 pieces of legislation. You're not dominant, so you can't abuse a dominant position. And if you're vertically integrated, you have much less need to have agreements with third parties, which could be potentially caught by the rules on anti-competitive agreements.
Thank you, Sophie. Just demonstrating that it is in fact all about competition.
No,
quite. So just moving a little bit more to the IP side of e-commerce then. Jeremy, what are your thoughts?
I can say there's actually little at this stage to say on the IP side of things for e-commerce sites. I think the IP angle is more for the content-based platforms that we'll look at shortly. In terms of copyright, when you're looking at an e-commerce site, it's difficult to see what copyright issues are there. Normally these e-commerce platforms are sort of trading goods and services, and there's the 2 issues there would be sort of trademark rights and then the distribution agreements which are in place, preventing maybe that platform from actually selling their goods or services, I should say goods in this case, goods outside the jurisdiction to which they've got their distribution agreement. And in that case, it's really looking at the distribution agreements, which is all about Sophie's area. And I mean, I suppose one thing I was trying to think about, is there a trademark angle to this? And often, trademark rights sometimes sit with the distribution agreements, in my experience, and there might be a situation, it depends on who the distributor is. It really is fact specific, and this is getting a bit theoretical, but you could envisage a situation where maybe you carve up your national rights so that you have a different subsidiary who is actually the trademark owner in each country of interest, who's controlling everything, and then they would have the exclusive trademark rights for that particular country. And so there's more control at a sort of a micro level, as opposed to this one entity who's controlling everything around Europe. And in that way, maybe you could get around the geo-blocking, so each member state has a different trademark owner, but then it doesn't deal with the distribution agreements in terms of what that entity would be agreeing with its, say, with its distributors. So from my perspective, there's little at this stage to say on the IP aspects for the e-commerce sites themselves.
Okay, well you touched on content there a moment ago, so if we were to turn now to, say, production and distribution content in the DSM, One of the main priorities that the European Commission has highlighted in the DSM strategy is to create media players and internet platforms. Platforms are a big thing that we keep hearing about, of the size and scale of those in the US. How is this going to encourage this?
I think what they're trying to do is to create the right environment to foster, I suppose, digital growth. And as you've said about this goal of creating these like Facebook-esque type entities which have an incredible range of consumers who are using them, and as I think you said, 350 million internet users. I think there's meant to be 500 million citizens in the EU at the moment, give or take a couple of million, no doubt. And so that, you've got this vast potential market that can be accessed by digital sort of platforms. And at the moment, there's these various barriers or impediments to fulfilling the stream of a single digital market, whereby these content providers or platforms or whatever digital digital entity you're talking about, where they can really make the most of this massive market base. And you can look at the impediments from barriers to creating the single market, which I think we'll look at shortly, that have been identified, such as ranging from different cultural, different territorial nature of copyright, and different licensing arrangements. And these barriers prevent the one market, which can be leveraged by these digital entities to make the most of ensuring their product can be accessed by about 500 million users. And at the same time, given these barriers, it means the consumer experience at the moment isn't actually what it could be. So the consumer, I know from personal experience, I sign up to every single content provider, and I think that's quite common, is that we because there's the issues with, say, content, you might end up not sticking with one entity which gets bigger and bigger, and you spread the love around a little bit. So the consumer experience at the moment isn't what is envisaged for this digital single market. So I think those aspects, that's what the Commission's trying to do. They're trying to break down the barriers to create this giant market, so these entities can access 500 million users.
Theo, what do you think on how
Yeah, so
to achieve that?
From my point of view, I think sort of one of the things one of their ultimate aims, if you like, and this came out through the leaked communication the European Commission are putting together on the European copyright framework. Their aim ultimately is to get to a single copyright jurisdiction for Europe. So that would effectively be a single copyright code for Europe, a single copyright title that could be enforced through a single copyright court, effectively. Copyright's probably the last area of intellectual property law in Europe that hasn't been unified in some way, if you like, from that point of view. And so that's their ultimate aim. But again, for very similar reasons to what Jeremy was saying about the impediments to a single digital market, there are quite a few impediments to actually getting to that ultimate goal, I think, not least of which, again, I think is the cultural background. In Europe, we've come from individual jurisdictions with very different cultural priorities, and as a result of that, our copyright law has evolved in a very different way from that point of view.
And so, looking at then barriers and issues that we're talking about, what are the sorts of things that are preventing the creation of a DSM for content in particular? Let's just stick to content for a minute. We've got some of the things we've heard about already. Is there anything else in terms of barriers?
I think that the three barriers I touched on it just before. I'd say the first one is actually ties into the two I'm going to talk about, which is cultural differences. As Theo said, you've got different attitudes to copyright law, but not just that, you've got actual total different cultures across Europe. It's not a case of, the US is the example, every state, there are fundamental differences, but ultimately they speak the same language, they're the same basic outlook and attitude. And I think in Europe, that's not the case. You do have quite different cultures, you've got different languages, you've got different interests, you've got different senses of humour. Not everyone likes Blackadder, speaks English and watches rugby. A lot easier, or actually I should say football and Premier League, I suppose. But it's not the case. So you do have these different cultural attitudes, and what that means is looking at the next two issues, which are sort of the territorial nature of copyright. So copyright, as Theo said, it's quite fragmented. It hasn't been fully harmonised at all across Europe, and whilst there's been a level of harmonisation, there's actually quite a lot of differences in the different laws. And what that means is that as a rights holder, a rights holder can fragment the market and have different agreements in different countries. Now that's quite beneficial for a rights holder. What it means for, say, a person who might have the rights for content in, say, the UK, that they've cleared the rights there, but then making that content available online. Well, what's the position in the other member states? Do they have to then clear rights in each of the member states where there might be a different holder of that particular right which they've got in the UK? So you could have potentially 28 different different licensees around Europe for the same sort of basic fundamental right, which has been licensed by the rights holder. And that fragmentation is a direct consequence of the territorial nature of copyright at the moment. The other aspects, I'd say, is then the market conditions. And market conditions derive from the cultural attitudes of people and values, and as well as the territorial nature of copyright. And so at the moment, basically, rights holders have, there's different values in different markets. I mean, it's blindingly obvious. And with, for example, take the example of Premier League football rights. They're a lot more valuable in the UK because the consumer here it's more relevant to them, and the rights holder can sell those rights for a lot more money in the UK, as opposed to, say, I don't know, in Italy, where there might be an interest in the Premier League and people will watch it. They won't be willing to pay the top dollar, I should say top euro or top pound, for those rights compared to, say, the English consumer. And that sort of differentiation in market value means that there is a, I suppose, the way that rights holders get remuneration means that they do look at different European countries, and the way they make their money all depends on what the market value is in that particular state, and that is actually I suppose an impediment to the function of a single market, because just different valuations in different markets means there is a fragmentation.
Are there any impediments from your?
Yeah, sure. I mean, again, I probably touched on it a little bit in the previous item I spoke on, but again, it comes down to probably, alongside the lack of harmonisation, probably the inconsistent harmonisation of copyright law that's taken place so far as well. There have been a few attempts to harmonise certain aspects of copyright law, things like the Information Society Directive, the Software Directive, even the E-commerce Directive to a small extent. Within all of those provisions, there have been optional extras that individual jurisdictions can implement alongside that. And what that's really meant is that you've got quite a lumpy copyright landscape, even in the harmonised parts of copyright law as well, which has made things very inconsistent. Alongside that, as I mentioned at the very beginning of this piece, you've got the real sort of spectre of piracy, which really undermines development of new business models. And I think the development of new business models will be a particularly key thing if we do move to a digital single market from that point of view. And with that kind of impediment there, that's a real barrier to those kinds of business models. Similarly, what's seen as the unequal bargaining power between the internet platforms and the content producers as well, that I think has got to be put right in order to be able to move to these new business models as well. Hopefully involving those internet platforms in those business models as well, I guess.
So some new business models. How else is the EU proposing to address some of these issues that we've touched upon?
The current
harmonise all these different issues. It seems like there's quite a lot sort of fragmentation we talk about a number of times, and how do you address that?
Gradually.
Or is it just a pipe dream?
Well, it could be. The current state of play is that the Commission's announced sort of a gradual response to making the dream happen, and the first step is they're really focused on portability, and I think maybe in a way that's sort of the low-hanging fruit whereby consumers can relate to that a bit easier, and so the current forecast is that they're going to introduce some legislation in the form of a regulation which will not sure quite what angle they're going to go for, but somehow allow a user the ability to access their content they've, say, acquired or purchased online in other European states. That's the first sort of step they want to take, and I'm not quite sure. They haven't announced any sort of actual terms of this type of legislation, but maybe it'll be just user focused and allowing the user the right, and that if anyone interferes with that right, they'll be in trouble. But that's not drafting right there. So that's the first thing. This portability is the first step. And then as part of portability, the next step is accessibility. And that's then just a wider approach to allowing content to be accessed online. And the two angles to that will be looking at licenses and then also looking at possible different legislations for the making available right. First, with respect to licensing, I will actually leave this to Sophie, but on licenses, as I've indicated already, you can have different licenses in different member states, and they've made it clear that they don't want to interfere with the territorial nature of copyright. So theoretically, these sort of territorial licenses may still be able to exist, but what they want to look at is the exclusivity granted in a license, and that would probably be looking at the rights given in the license and not making not preventing that licensee from actually, say, selling the products on or allowing people outside of their relevant market, not preventing access to those services or goods. But this is probably something more for you.
Yeah, I mean, I think from a competition perspective, in terms of how content is dealt with under competition law, it's a pretty unsatisfactory picture at the moment, because it's clear that companies are entitled to grant exclusive licenses for particular territories, but then they can't essentially put in place any of the other types of restrictions that they would need to make those exclusive licenses effective. And that's clear from the kind of the Premier League cases where the Court of Justice said no problem with exclusivity in itself. It's the having the absolute territorial protection around that which is the problem. And I think there just have to be more cases on this issue to really thrash out exactly what the parameters of this are. And to that end, the Commission has opened an investigation into a number of Hollywood studios in relation to pay TV contracts around the EU. So, at the moment there's not a great deal in the public domain about that, but it's pretty clear that is being seen as a bit of a test case for how content, as a genuine content that really benefits from copyright as opposed to sort of just broadcast rights, how agreements that seek to control where you can access that content are going to be dealt with under competition law. So it's I'm afraid it is a bit of a watch this space on that one.
Jeremy, are there clearance issues as well in this regard?
Yeah, definitely. And this comes back to the making available right or communication to the public. And I think at the moment there's different approaches to what is actually making available. And whilst there's numerous Court of Justice decisions on this issue, it's still unclear the making available right in terms of is it the upload, is it the fact that someone can access it overseas. There are issues around that, and what the Commission's looking at is clarifying that position so that it's quite clear if so this goes to accessibility, and they want to make sure it's quite clear if someone has the rights in, let's say the UK, and that right that licensee would actually make available that content online, that they aren't actually infringing other people's rights by the mere fact that content online could be accessed by other, say, European users in other European member states. And to do that, what they're looking at is they're looking for inspiration from the current satellite and cable directive, which in the context of broadcasting, so live simultaneous broadcasts, the current rules there are that it's a country of origin approach, so that if the broadcaster has cleared the rights, let's say in the UK, and they broadcast that content, the mere fact that it can be accessed, say, overseas, by virtue of their broadcast footprint, because obviously you broadcast, it's over the airwaves and people can pick it up in other countries. The fact that they've cleared the rights in the country of origin is sufficient to prevent them from being an infringer in other countries. So that the Commission's suggesting that maybe that type of regime could be expanded into online content, but in the context of on-demand TV programs and radio programs. So again, if you've say made it available in the country where you've cleared the rights, that fact will suffice to prevent you from being an infringer when other users in other member states where you haven't actually got a specific license, if they accessed it, you wouldn't be infringing in those countries. And similarly for just general online content, not just radio programs or TV programs, in the context of making available, that maybe that they're looking for inspiration from the Satellite and Cable Directive to bring in an interpretation for this country of origin suggestion, where if you've made it available in the country of origin where you've cleared the rights, that will give you protection, despite the fact that it could be, say, accessed in other countries where you haven't actually got a specific license for that content. So that's the type of clearance issues that are currently being discussed at the moment.
And Theo, just moving back to copyright then, what are the sort of areas of harmonisation that the European Union is looking at as part of this sort of approach to solve these issues?
Yeah, so obviously at the moment they've made it clear, I think, that they're not going to be able to get to that sort of utopia of a single copyright for the European Union. I think that at the moment they're looking to, again, pick the low-hanging fruit. So it's really all about trying to knock out some of the lumps that are in the current harmonised regime already. So I think they've realised their mistake with things like the fair use defences that they've made optional in a lot of European countries. They will probably try to move more to a mandatory regime around that. Alongside that, some of the sort of the important issues around private copying, for instance, where those sorts of exceptions can be applied, whether specific levies have to be put in place on either media or the people who are distributing the content or not. These sorts of issues will be very relevant as far as that's concerned, and that's an area where in the UK we've already come a crop up when we haven't actually applied those kinds of levies to our private copying exception. That particular part of the new law being ruled illegal by the courts over here, obviously. Alongside that, I think the other area where they'll be looking at further harmonisation and trying to simplify matters is dealing with piracy. So within this jurisdiction already, we've obviously already got quite streamlined procedures for obtaining disclosure of people who are hiding behind particular Twitter handles, whatever it may be, internet handles, to avoid being seen. We've also got things like site blocking orders in place. Again, the way that is implemented across Europe is rather patchy at the moment, so I think they're trying to sort of make that a more consistent coverage across Europe, and also trying to simplify it. I think they will try to move to a position where you can get one order that will ultimately cover the whole of Europe as far as that's concerned. The other area they're looking at from this point of view is also follow the money measures, so whether you can actually go to the credit card payment processors and try and cut off piracy at that stage as well, so that people can't actually make money out of piracy. That's another thing they're looking at this stage. In terms of levelling the playing field vis-a-vis internet platforms, there are sort of two main areas I think they're looking at here, which I think will be quite sort of groundbreaking if they manage to get there. That's, on the one hand, looking at some of the e-commerce defences, the hosting defence, the caching defence, the mere conduit defence, which are areas that so far the internet platforms have hidden behind. They do have notice and takedown procedures, but they tend to be individual notice and takedown procedures. So once you've taken down the content, it will tend to get posted again. The rights holder's got to then come up with yet another notice to get that content taken down. So you're playing the whack-a-mole sort of game as far as that's concerned, so they're going to look at that. Alongside that, and Jeremy's already touched upon it again, it's looking at the communication to the public, making available rights and the definition of those rights, because again, that's something that the internet platforms have hidden behind, that lack of clarity around what those definitions are, to try and avoid liability. So I think that's probably the main areas that they're going to be looking at as far as my areas of interest are concerned, if you like.
So in conclusion, if I put each of you in the spotlight then and ask you to come down on one side of the fence or the other, where do you, each of you, for your own particular area, see this ending up? Jeremy, let's start with you.
I think there will be clarity on portability very soon. I think that's clearly something they're absolutely focused on. I think then accessibility. I mean, I actually think all these steps which I discussed will come in at some stage. I think portability will be resolved. Accessibility will be resolved somehow, because I think at the moment it's unclear anyway. So that needs to be resolved. But ultimately, I might put a marker down and say I think there will be eventually a unitary copyright. It's so clear this is what the Commission wants. You know, everything they've written about is just clearly steered toward this one unitary right. You know, there's a copyright single. You know, there's a trademark. There's the community trademark. There's the community design right. We're now having a unified patents court with the unitary patent. You know, if they can do it for those kind of rights, copyright. Well, whilst there's different traditions involved in copyright, you know, you can see they're clearly steering. It's a long-term project. It's not going to happen in the next few years. Maybe in 10 years' time. So that's what I think from a purely IP angle, and that's what's going to happen.
Sophie, what about you?
So, I mean, I've already kind of mentioned a couple of things. I think, you know, there is going to be a review of the rules on vertical agreements, so distribution type agreements, and which may lead to a bit more clarity. But what tends to happen is that, you know, some things will be made clearer, but then there'll be other ways of interpreting what's been said. So I think there will also be test cases. And I think it's also fair to say that, you know, kind of by analogy, again, with the analogue world, look at the Commission's car price monitoring. It did that for a number of years to try and work out what the differences, why there were such significant differences between different member states. And although the differences closed a bit over time, partly through enforcement action, they still remained. And in the end, the Commission stopped monitoring car prices. And I think, you know, similar issues are going to apply in the digital world. There's going to be imperfect enforcement and imperfect competition for many years to come.
And Theo, finally, what's your take on it?
So I'd agree with Jeremy. I think ultimately we will move to a fully harmonised copyright law across Europe. I think probably one of the keys to whether that's going to be a success or not will come down to the enforcement regime. I think with a lot of the harmonisation of IP rights that's taken place so far, we've moved to a local method of enforcement. If we do that with copyright, I think inevitably the cultural differences that exist between us in Europe will probably start to play a role, and we will still get a rather patchy element to enforcement as well. So that's probably a key issue there. I think alongside that, on the piracy side of things, clearly everybody's pushing in the direction of trying to simplify the blocking of content and sort of the following through and identifying who the infringers are here. The only issue that is always a contentious one is who is going to bear the cost of that. Is it going to be the content producers and distributors, or is it going to be the guys who are effectively providing the technology as far as that's concerned? And that will be an ongoing battle. In terms of the internet platforms, again, there may well be a need to redress the balance there. However, I think what we've got to keep an eye on here is that in looking to address that balance, we don't cut off some of the innovation that's taken place by those internet platforms as well, which is going to be really necessary in terms of moving us through to what the European Commission wants here, which is the digital single market.
Thank you. Before we move on to our next panel, can I just open it up for any questions from the floor? Yes.
I just have a question on the geo-blocking, which is a bit more of a practical one, really. If e-commerce websites are required to start putting in place a geo-blocking sort of regime, does that mean that businesses will be required to, for example, ship products from one particular distribution centre to another territory, which they don't normally kind of have that logistic framework to do so? Because there's obviously some practical issues. It's not necessarily just kind of pricing regimes and things, that there are reasons why they're not available Europe-wide from the same website, because they're actually sourced out of different distribution centres. Sometimes with different products, in fact, as well, because they're not available to be going everywhere. There's just not sufficient stock, for example.
Do you want to pick that up?
With that, I think one of the things that has been identified as potentially justified geo-blocking could be the inordinate shipping costs involved for some products, for example. So I don't know if you have a massive piece of machinery and you have to then ship it across Europe. that's ridiculous. But so I think maybe that could be a circumstance for justified geo-blocking. And in some of the Commission documents at the moment, what they have identified is I think there's a whole section on parcel delivery services in the EU, and whether it's worth somehow trying to create a more efficient parcel delivery service, which would actually, I suppose, overcome those issues in relation to potential shipping costs, preventing that business from actually having access across Europe. So yeah, again, that's a watch this space, but you could argue that could be a justified reason for geo-blocking, because they simply don't have the logistics in place to actually satisfy the consumer demand around Europe.
I think from a competition perspective, provided you're not kind of prohibiting people from selling into those countries, so it's more of a de facto, well, that's how it works, then I don't think you're going to come up with issues in relation to that particular type of restriction on distribution.
Any more questions?
That's another one related to geo-blocking and the territorial nature of copyright. In the content industry, broadcasting very much works on a territorial basis. And the case of the investigation we talked about, Sophie, moving investigations really something. What's going to happen there is something really something interesting for us and quite scary. I'm just interested to see what you think about justified geo-blocking for broadcasters. How do you think that's going to play out?
It's tricky to answer that question. I mean, clearly because copyright is national in scope and territorial in scope, that's something that the Commission is going to have to take into account and work out to what extent it can effectively erode that by using competitional tools. And with the Premier League case, it was about there were broadcast rights, but ultimately there were no actual IP rights in relation to the football game itself. The only IP rights were in relation to the kind of intro music and stuff that was at the beginning of the programme. So the competition authorities and the courts haven't yet had to grapple with a true copyright protected issue. And I suspect that what we might see is that they'll do something more around the edges. There'll be something about the agreements that goes kind of well beyond protecting the copyright. But without more insight into really exactly what the investigation covers and timelines or anything, it's quite hard to see how it's going to play out. And ultimately, even if the Commission reaches an infringement decision, that will of course be appealed. I mean, we know that success rates on appeals of competition decisions are pretty low, but there's still quite a way to run with that, unfortunately. But we will definitely be keeping an eye on it.
And I think one of the interesting things on the IP side of things that's cropped up so far is the whole idea of whether you can have exhaustion in a digital file or not. And at the moment, there's been the Usoft case, obviously is now seen, I think, as an exception more than anything else. I think the key thing, though, with copyright is that if we do move to a single copyright title for the whole of the European Union, then I suspect to the extent you try to divide up the market at that point, Sophie's competition issues will become a lot more relevant at that point.
Any other questions? No? In which case, thank you very much to our panel, and we invite our second panel up. I'm actually going to switch seats away from chairing this one and invite Theo to come and take the hot seat. Move along.
So, moving on to the second side of things, I think this is more about maximising the exploitation opportunities out of the digital single market. We've got Mark Watts here, Louise Eldridge and Adrian Sim. Guys, do you just want to introduce yourselves very briefly?
Very briefly. I'm Mark Watts. I'm a partner here. I head up the commercial IT group.
Louise Eldridge. I'm a partner in the corporate team, specialising in M&A and venture capital, which is more relevant today.
Adrian Sim, partner in the commercial IT team with Mark as well.
Thanks, guys. So you each specialise in different areas. What do you each see as the key aspects coming out of the digital single market? Mark, do you want to go first?
Sure. So for me, the two things I'd mention would be cloud and data. I think with those two, the thing to bear in mind is that much of what you've heard about the DSM this morning is trying to look into the future and see where things are going. With both cloud and data, the Commission has been at it for a while. So its paper on unleashing the potential of the cloud came out in 2012. So we have a reasonable idea as to where that's heading. They see it as terribly important. I think, did you say 415 billion?
Yes. Yeah.
So they're attributing about 80 billion of that to cloud computing, both from the point of it being a technology itself and its own market in that sense, but also as an enabler of some of the other content distribution or e-commerce things that you've already heard about. And then equally on the data side, many of you will be aware that there's going to be a new data protection regulation. We think the ink will be dry on the 28th of December. That's the latest we heard, no guarantees. They've been at that since January 2012 as well. So we have a pretty good idea as to where cloud and data are going as they relate to the digital single market. And of course on the data side it's very current at the moment. You'll all be aware of the Schrems case and that pesky Ed Snowden who's ruined everything for everybody in terms of data transfer. So we can talk about that if necessary.
Adrian, how about you?
I guess for me, focusing on sort of the e-commerce elements of the DSM agenda, you've heard a lot about the geo-blocking, and that's obviously very relevant to e-commerce platforms and how they operate, but also from a consumer perspective, getting access to a broader range of goods and services. But for me, the one thing that's going to be particularly interesting is this amended proposal for the Common European Sales Law, which is now being rebadged as the EU Online Sales Act. And what they're looking to try to do under that broad umbrella is looking at harmonising online sale or distribution of content, which has happened to a large extent already in the UK and a couple of other jurisdictions like I think the Netherlands and Ireland have similar regimes now. But for the rest of Europe, digital content isn't really covered in any of the existing regulations. But also looking at whether or not they can come up with a mandatory set of sort of key contractual provisions or key rights and responsibilities in respect of both domestic and cross-border sale of tangible goods as well. So that's all potentially going to come under this new EU Online Sales Act. The Commission's still in discussions or still considering exactly how it's going to approach that, and it may range from full harmonisation to combining sort of a low level of harmonisation with the country of origin principle, which I know Jeremy mentioned in relation to content, but it might also apply to e-commerce websites. So at a very high level, country of origin, if you are established in a particular jurisdiction, it would be your laws which would apply. And the real rub is at the moment, obviously under the Rome 1 regs, consumer protection in particular jurisdictions is still observed and still sort of has primacy over those. And it's looking at what the Commission might do in respect of how they marry up this sort of traders law or the country of origin principle with the Rome 1 rights that they have at the moment. So for me, it's something that's going to happen. They're proposing to make an announcement by the end of this year, and we'll see whether that actually occurs. But if it does, I think it could really change the way that e-commerce platforms have to interact with consumers and the types of rights that consumers will be able to access to any goods or services they buy across the EU.
Great. And how about you, Louise?
And from my perspective, looking at the venture capital market here in the UK and across Europe, it's really about opportunities that will be opened up as a result of the DSM for growth companies, growth technology companies particularly, looking at how their reach will increase on having a more pan-European access to consumers effectively, and how that there's a sort of corollary there in terms of how attractive they are to VCs and to funders. There's a lot of very jurisdiction-focused VC funding that goes on at the moment, where lots of London VCs don't want to invest in a company that isn't based in London. US VCs traditionally, although it's changing a little bit, but are not that interested in investing in UK companies. And so there are opportunities off the back of the DSM for I think for some repositioning to go on for growth companies in Europe to look more attractive to VCs from other countries in Europe, and equally for growth companies in Europe to look more attractive to VCs across the pond from our US friends, where traditionally there's been a lot more capital flowing around and flowing into those companies, and it's one of the things that the Commission has identified, as we've mentioned and touched on earlier. You know, one of the things that they're trying to achieve is that we have these big platforms coming out of Europe, rather than, you know, just hearing about the Amazons and the eBays and so forth, and these big US success stories. That to really try and grow that, we need to grow our own growth company market, and that all really stems from funding.
Great. Well, I think what we're going to do now is try and drill down a little bit into each of those areas. Turning first to you, Mark. You've indicated cloud computing could be a significant catalyst for the digital single market. Mm-hmm. What do you think are the main legal obstacles to cloud computing realising its potential?
Okay, so we're almost at the point, I think, where I don't need to explain what cloud computing is, things like this, but maybe not quite. So very, very briefly, back in the day, if you needed more storage, you'd go and buy a new server. If you needed a piece of software to do something, you'd go and buy a bit of software. These days, you can get the storage, the compute power, and the functionality remotely through your browser via a network. That's it, essentially, simplifying massively. So there's a very obvious obstacle that one needs to overcome from a practical point of view, which is you need decent broadband. So you need high-speed internet in order to be able to make use of that sort of technology. So there's a whole piece around the telecoms market in Europe and where that's heading. Getting more into the legal obstacles, probably the one that we get asked about the most is in relation to data security. All the time we get questions such as, so is the cloud safe? Can I put my data in the cloud? Is it at risk? And as a rule of thumb, the more regulated the business, the greater the level of concern, because often the more sensitive the data. It's financial data if it's a bank, it's health data if it's a healthcare provider or pharmaceutical company or something like that. So is it safe? Well, I don't know. I think what I would resist is the assumption that it is inherently less safe. So I think if you were to compare a service provider that makes perhaps all of its money out of providing services to its customers and being a custodian of their data, they are more incentivized to have good security than a fairly small outfit that maybe has a low IT budget and has got a couple of servers down the corridor, maybe without even a lock on the door. So it seems to me that one could almost assume that it's more safe. But essentially, in order to answer that question, it very much depends on who they are, where they are, what data it is. You're going to have to do some diligence and some audit and have your questionnaire to bottom out the security. And probably the thing we hear most about these days in relation to data is security, hacking. We all were aware of the TalkTalk piece recently. That is not unusual. It's not quite a weekly basis when a client is hacked, but it's that sort of level where we will be involved in some data breach or another. So security is massive. The other one that's related to that's terribly important is the role of standards. So when you're looking at the security of some of the cloud offerings, it's very hard from a distance to judge whether it's safe or not, and so you have to rely on some of the certifications that they have to various standards. So what you see at the moment is the various cloud providers all sort of vying with each other to who's got the most security badges. So who's ISO this, who's got a SOC 2 Type 2, who's PCI DSS, whatever it is. So these security standards have an incredibly important role, particularly for as long as the various T's and C's are as non-negotiable as they seem to be at the moment. And then the other piece to standardization is not looking at it at a security point of view, but looking at it from a data portability point of view or an interoperability point of view. If you've got services, this isn't a great example, but it'll be a sort of intuitive one. If you've got a service like Facebook and people need to be able to move from Facebook to, say, I don't know, Google Plus, Snapchat, whatever, a rival platform, then you can see that taking the data from there to there would require the format to be at least the same or easily translatable from one to another. And that's a terrible example from a consumer point of view, but in a business sense, that idea of the data format needs to be agreed, prescribed to some extent, is really important when one's talking about interoperability. So that's another bit of standards. T's and C's, I think in conjunction with Christopher Millard, who's part of the team here, we've been looking at the market for cloud terms and conditions for a few years now, and it's interesting watching how they go. They're getting better a little bit, but essentially the view is still standard service, standard pricing, very, very low margin. We're not going to take on any additional risk, so these are the terms, they're non-negotiable. Now the Commission, in connection with the DSM, has taken the view that actually what we need is to promote the uptake of cloud. That will go better if there are more balanced and fairer sets of terms and conditions. So business, sort yourself out. We want to have some standard terms that are a little bit more evenly balanced. And there's some way to go on that, I would say. And it's a slightly simplistic way of looking at it in terms, because all these services, sure, they're all cloud, but they're very, very different actually. And so maybe they can't have the same terms. Coupled with that, there's been a lot of work on a code of conduct for the various cloud service providers. So there are some common issues and between the providers. And the view is, well, wouldn't it be good if they all signed up to a code that dealt with, can you come on site and audit our premises? Because they really hate that on the whole. What about law enforcement access? Can the police get their hands on your data? What about things like transparency? What about data transfers? Why don't we have an industry code that just lays it all out, everybody signs up to it, and that in a way will become a de facto standard? And a lot of work has been done on that. We're not quite there yet. Quite controversial, been driven by some cloud providers, maybe to the disadvantage of others, but we will see where that ends up. And that's probably it in terms of cloud, I think, for now.
Great. So you'd also mentioned in your introductory bit General Data Protection Regulation.
Yes.
That, I believe, is likely to have a significant impact on digital technologies.
Yes.
What sort of new technologies are likely to be most impacted by that, and how?
Okay. So in a word, all of them. I will elaborate, but. So we're going to have a new law, a new regulation, immediately effective in each of the countries. As I say, we think it's going to be signed on the 28th of December, but then there'll be a few months while they all sort themselves out and publish it in the official journal, and then a couple of years after that it will come into effect. Why have we got it? Well, because the Commission eventually was persuaded that with the previous law having been written before the web, apps, big data, social, you name it, we needed a law that was more responsive to new technology. So then they went off and they wrote the law that for many of us is probably as ill-suited to new technology as it's possible to be. But anyway, there we are. It's going to happen. It still has an export ban on data transfers. So the fact that even in this room, while I've been talking, people have probably been transferring data out of Europe, that doesn't matter. The fact that it goes on all the time doesn't matter. We should still have it as being illegal in the same way as we have at the moment. So it doesn't really fit the connected networked world at all. How will it affect business? It will put a significant obligation on business to have a compliance program. Right now, it is not a wise choice, but a legitimate choice to not have a compliance program at all in relation to data other than keeping your fingers crossed. When we have a new law, you will, by law, be required to have a compliance program, and the absence of that program will itself be a breach. Even if you don't lose any data, that will still be a breach. And then the sort of scary private practice lawyer bit, the fines are humongous. So the low watermark is 2% of global turnover. The high watermark is 5% of global turnover. And right now, the Commission, the Council and the Parliament are thrashing out whether it's going to be 2, 3, 4 or 5 in terms of the size of fine that is available as a maximum.
Great. So picking out one new technology in particular,
Yep.
How will the data security regulatory landscape impact the Internet of Things?
Okay, so the one I wanted to pick out is my favourite, hopefully it's relevant, which is the Internet of Things. So how many of you got some kind of Fitbit or wearable or something like that? Few kind of shy hands going up. So a wearable is a good shorthand in some ways for Internet of Things. So it talks to your phone, maybe it talks to your scales or whatever you've got it talking to. That's good. It's good in some ways because it's so sort of simple. It's terrible in other ways because it's a silo, it's proprietary. So your Fitbit will talk to your Fitbit app, will maybe talk to something else, but that's it. When we're talking about Internet of Things, we're talking about a level of super connectedness that you can't even contemplate. So in terms of connected cars, you want your VW to, in real time, talk to the Ford that's approaching while it talks to the traffic lights, and then send something to, I don't know, the ambulance or your insurance company, whatever it is. So everything will have sensors and will need to communicate. That's where the Internet of Things is going. It sounds sort of vaguely science fiction-y, but they're talking about 2 or 3 years away. There will be a lot more of this surrounding us than there is at the moment. So what does that mean? Well, everything is going to be sharing data. So a data protection law that restricts sharing data is on the face of it a problem. You have a law that stops some of that interaction and data sharing that you need to realize the Internet of Things. That's the first thing. Now the other thing, what's the other impediment to the Internet of Things? Well, actually, all these things sharing data, people won't share data unless they're pretty confident about how it's going to be used by whoever gets it. So there's a lot of trust involved. So ironically, in order to have data sharing, you need restrictions on data sharing. Does that make sense? So where this heads is, for the Internet of Things, we need laws that they enable sharing, but are sort of realistic enough that they don't snuff it out altogether. Because if they do, then a lot of the things that are, such as cloud, apps and Internet of Things, will find it harder to realise their potential and support the digital single market.
That's great. Well, thanks very much for that. Obviously quite a lot to be going on there, and already in train as well, I think.
Yes.
Turning now to consumer and online sales law, Adrian. The Common European Sales Law failed to get through the European Council. This new attempt through the EU Online Sales Act, do you think that's likely to be successful?
Yeah, I mean, it's difficult to say. It's still in the stage where the Commission's going to put out a proposal, hopefully by the end of the year. But I think they're pretty aware of why it failed. So it was put up in 2011, didn't get through the Council. It officially sort of died at the start of this year. But what the Commission's proposing is to resurrect that in part. So whatever happens, they know there will be elements of that will be incorporated into this new EU Online Sales Act. But I guess it's a question of which elements they incorporate, because they are quite conscious of some of the issues of the first attempt. And I think part of that was that it was quite a cumbersome approach. Like, they were proposing a regulation, so directly applicable to all the member states, but then at the same time there was an optional element, so businesses could elect whether or not to enter into effectively like a model contract for sales, and then the consumer then also had to agree. So you had this mandatory regime with an optional element, and there were constitutional issues as to whether they were able to do that in the first place. But also, I think the original attempt tried to cover a whole lot of ground that the Commission's really conscious of, and so they've narrowed the scope quite a lot. So the old attempt was B2C, but also B2B contracts, with the little proviso that you had to be an SME to gain the protection or be able to use that, whereas now they're focusing almost purely, I think they will focus purely on business to consumer relationships. They're looking at narrowing sort of the scope of also what it's going to regulate. So it will be content, but also most likely tangible goods and some sort of ancillary services as well. And they're focusing really on online. So previously they were looking at online, but also every method of sale. There is some discussion that the Commission is quite aware of sort of omni-sale channels. So, you can have retailers that are online, in-store, over the telephone. So there is a possibility that they may also go down that route to cover some additional methods of sale. But I think it's more likely to happen because the Commission's also looking at harmonising all the relevant, e-commerce directive, consumer rights regs and consumer sales acts, and also the unfair contract terms regs, which they didn't do first time around. So they were going to sort of operate this parallel system, whereas now they're taking a more considered and conformed approach, and I think that's going to keep the member states a little bit happier. So fingers crossed it might actually happen this time round.
So you've already mentioned some of the things it's going to cover. What else is the EU Online Sales Act going to cover?
Yeah, I mean, it could be quite a range of things, but the three main sort of areas that they're really focusing on are the remedies. So we know in the UK there are sort of two tiers of remedies. You know, if they can repair or replace it, in most instances that's what they have to do first, and then if not, you get sort of the refund, termination, sort of damages potential remedies there. So they're looking at what combination of remedies are going to be available and whether we'll have also this two-tiered system. And like in the UK, will it be different if it's a tangible good or a digital product? And then also time limits, not only for warranty periods, but really time to exercise the right. So, you know, the automatic cooling off period, but then also if there's an issue with the product that you've received, like it just doesn't conform with the specification, how much time do you have to bring a claim in respect of that? And then finally, which I think is potentially quite a scary concept, is they're looking at the quality of goods. So, you know, warranties are fitness for purpose, meeting the requirements or the specification, and specifically whether or not that should be judged on an objective basis, which to me seems the most sensible, or a subjective basis, which I'm not really sure how, you know, how retailers would really deal with that if every individual or class of individual has a different view as to what a particular product should do. So we're hoping the Commission comes to a sort of sensible conclusion on that. But those are the three main areas. And I mean, I know Mark was talking about cloud. They're also looking obviously at, you know, cloud contracts come into this scope as well. And one of the issues that exists with cloud are sort of longer term subscription arrangements. So one aspect which they might also address is whether or not there should be specific abilities for consumers to be able to terminate cloud arrangements, you know, on a shorter notice period, because obviously some of these arrangements go for quite a long period of time.
So this still sounds pretty ambitious. Does the Commission have any backup plans if this doesn't come off?
Yeah, I mean, in my sort of view, like the full harmonisation would be great, both for consumers and for retailers, but the Commission has floated quite a few options. So there's been a paper out of both the Commission and the Parliament looking at sort of the initial impact assessment and then a more detailed analysis of what might happen. And in that they talk about full harmonisation either through a regulation or a directive with full harmonisation provisions within there. But also, as I mentioned at the start, this country of origin principle is something that they're looking at. So they're shorthanding that as the traders' law, where if they don't have full harmonisation, what they might say, and this would really benefit, you know, your e-commerce platforms, is that it's your laws which would apply. And that's one element that, you know, was specifically called out in the DSM agenda paper, which, you know, kicked all of this off. But has also been talked about a little bit more in recent sort of releases from the Commission. But I think also what they might end up doing is sort of combining the two. So even if they don't have a regulation which directly applies, they might end up with a directive plus a change to, you know, this country of origin principle. And what will be really interesting is how they then deal with the consumer rights remedies that consumers would have in various jurisdictions, which at the moment, under the Rome 1 directive, would apply. So I think what they'll end up doing is maybe tweaking that or having to provide for that as well, and maybe lift the sort of minimum harmonisation level so that the consumer rights across the board get a bit better. And so hopefully consumers in jurisdictions where there are great protections at the moment will have a bit more comfort, and, you know, those parliaments will be saying, yeah, we can probably accept this new regime because you've lifted the minimum consumer rights protections across the board. They may not be as high as we had specifically in France or Germany, but our consumers, you know, get a benefit of a broader market. So those are some of the fallback plans that I think they might end up adopting or at least considering.
Great, thank you. So I guess we've seen that the digital single market's got a number of facets here. It seems to me if ultimately it's going to be successful, we need lots more innovation, lots more disruptive technology coming through. And I think one of the key things to that, Louise, is probably your area around corporate finance, how that's really going to be financed. Just to give us a bit of background to this, what does the VC market look like now without the DSM? And what could the DSM do for the venture capital market?
Well, I touched on earlier the sort of issue at the moment with how the VC market typically works, more or less, is it's quite fragmented by jurisdiction. There are some exceptions to that rule, but they, on the whole, are fewer and farther between. So you have, you know, UK-based VCs funding in UK-based startups and growth companies. And we see that across Europe, and we see, you know, the US VCs traditionally like to invest in their own early stage companies, and a lot of that is about the size of the market. for the US VCs. They look at their own market and they think, well, actually investing in a UK-based, let's say a London-based company, for example, doesn't necessarily, because we're part of Europe, doesn't necessarily translate that actually that particular company has access to the market in terms of sales stream in the same way. I know Sophie mentioned earlier some of the e-commerce problems with Germany and barriers to entry there that e-commerce companies can have. And so I think the whole idea of the digital single market, really from a VC perspective, is looking at access to funding for companies that are in our own market but across Europe. And I think there'll be winners on lots of different levels for that. There are some potential drawbacks, of course, but if we can make companies look more scalable, and it's all about scale. I know Sherry Kutu, who many of you will be familiar with, has recently taken on the executive chair role of the Scale Up Institute. She was cited recently saying that one of the key issues and barriers to entry, we're just not getting enough scale-ups coming through the UK, and that's really about funding and resources. So funding, probably the most important part to it, and then the access to employees and good engineers and all the rest of it sort of comes with that. And so really it's about trying to break down barriers and make the market look bigger, and therefore the companies playing in that market more attractive.
So that's great. So you mentioned barriers there. What actually are the barriers to this being achieved?
Obviously there's the cultural issues that we touched on earlier, and whether the DSM can really achieve this idea of a utopian pan-European society where everybody's operating across borders digitally without any hesitation remains to be seen. There's undoubtedly what's familiar is going to be more comfortable to a lot of people, and VCs will tend to, I suspect by human nature, want to favour playing in their own market where they understand the cultures, they understand the infrastructure, the legislation and so forth. So there's that issue that needs to be broken down. So when we're talking about the digital single market, they'll need to look very much about infrastructure for funding and regulation, and make sure that all of the sort of wider issues that will affect that are taken into account, and it's not just looking at breaking down borders. Language is another barrier, obviously. I think there was a study, a Harvard study found, countries which share languages trade 42% more with each other. So clearly, there is some issue there that we can break down digital barriers, but if there's a language issue and people aren't, online in a common language, then that's going to have a repercussions. And I guess economic stability and political stability, not all member states are perhaps seen with the same economic stability. Another issue.
So what's all of this going to mean for European tech companies then?
I think on the whole I'm quite positive about it. I think access to funding is an issue, and for me I look at the opportunities as being far greater than the potential problems. I think the problems can be overcome. It's just about how the digital single market is shaped in the coming months and years to make the terrain look attractive for venture capitalists.
Great, that's really helpful. So coming back to you, Mark and Adrian, just in terms of summing up, is the digital single market going to be a positive thing for businesses and consumers, first of all? Mark, do you want to go first?
Yeah, sure. Yes, I think so. I hope so. On some of the bits that I spoke about, whether it's going about it the right way, I think is an interesting question. So if you're trying to get people to comply with, say, the way they handle data and stuff like that, there's a question is, do you set the bar impossibly high, and in the hope that as people try and get there, they'll just get a bit better? and really better is enough? Or is it better to set the bar a little bit lower, a bit more achievable, a bit more common sense, write laws that business people can understand without instructing lots of lawyers, and drive it that way? I would prefer that. I think what we've got is the first one. And then I think there's also a question about the fines. Having these huge fines, it doesn't make sense to me. I think there's a bit of envy going on when they look at the antitrust guys and competition guys. They think, oh, we'll have a bit of that. Wouldn't it be nice? And so I think the problem you have is that you could say, well, it's a real deterrent if you've got a super high fine like that. But it's only a deterrent if it's clear what behaviour you mustn't do, which requires the law to be clear and simple and kind of relatively easy to understand. I think we're a very long way from that at the moment. So overall, DSM, I think great. The DP component, I think, is I think we're stuck with it, but it's still a work in progress, I think, on the whole.
Okay, that's great. And how about the other side of things, Adrian?
Yeah, so from an e-commerce perspective, I think it's the same. I think it will be a really good outcome for both consumers and for e-commerce platforms or traders, especially if there is this full harmonisation, because from a sales perspective or a trader perspective, you're going to have this initial hit where compliance costs will go up just to get the new regime in place. But once you have it, your ability to roll out to different markets will be much greater. You'll obviously have to deal with issues that I think were raised from the floor before about delivery and just practical issues like that. And the new revamping of the parcel directive and how that's going to work is hopefully going to address some of those issues. The one area where it may not be so great for consumers, at least, is if the Commission does end up having this sort of hybrid model of looking at the country of origin principle and really enshrining that, which would be great for e-commerce platforms because they're like, okay, well, our existing regime works, we can roll out across Europe, even if we're targeting different markets, especially if the Commission sort of overrides the Rome 1 regs, then that's been quite a good outcome for e-commerce retailers, but not so great for consumers who may lose quite a lot of protection. But I think where they may end up is a hybrid of the both, where they lift the minimum sort of standards for consumer regs, in which case hopefully it's still a win-win for both groups.
Right. And Louise, from your perspective, is it a positive for European digital businesses and VCs?
I think so. I think the idea of breaking down some of the issues that are preventing UK companies and indeed European companies from scaling can potentially be addressed by this greater market opportunity, which will look more attractive to funders.